Today, we are going to be talking about certain legal fictions and the concept of indigence. It is something which governs all of our lives, and we are little, if at all, taught about the subject. Of course, a government, which is a corporation and serves corporate interests, has no reason to teach us about indigency or legal fiction. And of course, this is indigency, or the state of being indigent versus being indigenous. According to Cornell Law School, indigent means impoverished or unable to afford the necessities of life. A defendant who is indigent has a constitutional right to court-appointed representation, according to a 1963 Supreme Court decision, Gideon v. Wainwright. And then if we look at definitions.uslegal.com, it says that indigency, or lack of ability to pay, is a legal reason for having certain required fees waived, being declared eligible for free services, or appointment of legal counsel. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. Therefore, people who cannot afford to pay for a lawyer may have one appointed for them. There are also constitutional due process requirements applicable to an indigent person, access to services and processes in the legal system. Often there is a statutory requirement that an affidavit of indigency be submitted in order to have a legally required fee waived, such as a court filing fee. Now, it also states that indigency refers to persons who have a significant lack of income. Indigency is governed by various federal, state, local, and administrative laws and rules which vary. It is often defined by 1. The receipt of certain public assistance payments. Income after taxes which does not exceed 125% of the current federal poverty guideline. Or 3. That a person cannot pay required fees or costs without depriving themselves or those who are dependent on them of the necessities of life, including food, shelter, and clothing. Now, when we go to a executive order number 13770, dated January 28th, 2017, and signed by the President, Donald J. Trump, we find it mentioned about a public trust. It says in Section 1, under Ethics Pledge, every appointee in every executive agency appointed on or after January 20th, 2017 shall sign, and upon signing shall be contractually committed to the following pledge upon becoming an appointee. As a condition and in consideration of my employment in the United States government, in an appointee position invested with the public trust, I commit myself to the following obligations which I understand are binding on me and are enforceable under law. And then in a different section, it states that under Section 5, Enforcement, subsection D2, it states that establishment of a constructive trust for the benefit of the United States, requiring an accounting and payment to the United States Treasury of all money and other things of value received by or payable to the former officer or employee arising out of any breach or attempted breach of the pledge signed by the former officer or employee. And under Section 2, subsection J, it states that former employer is any person for whom the appointee has within the 2 years prior to the date of his or her appointment served as an employee, officer, director, trustee, or general partner, except that former employer does not include any executive agency or other entity of the federal government, state or local government in the District of Columbia Native American tribe, or any United States territory. Now, what does this all mean? To summarize it in a easy to digest manner, basically means that there's a public trust which is paid into by a variety of entities, and it is charitable, intended for the monies to go to indigent people or persons. Now, being declared indigent means that the other beneficiary of the public trust, such as the U.S. government, will pull a certain quantity of monies to support that indigent person. Of course, as is often the case, the majority of that money goes to the pockets of corrupt politicians, while a small portion goes to the indigent person. This is also used to try people in the fictitious courts, and once declared indigent, a representative is appointed to that person, a lawyer or attorney, more often than anything else. And those will be ascribed and assigned by the court. No conflict of interest there, of course. And the court-appointed attorney, taking the power of attorney for the indigent person who has been declared incapable of managing their own life, will be sentenced to prison regardless whether or not they actually committed any sort of action or they're actually being held accountable for anything real. Because first, the court is fictitious, and second, it is acting as a beneficiary to the public trust. And having declared the defendant indigent, and could be the plaintiff as well, essentially that person loses all rights because they are taking money from the public trust. That is essentially the idea in a nutshell. And of course, all of these services were intended for a different purpose in the way that they are used. But we have a general concept of what is a public trust and what is indigency, and the reason why it seems that our court systems are so corrupt, at least our fictitious court systems, which essentially could be compared to Shakespeare bringing the fictitious identities of individuals, such as your legal name, to trial, and then holding that fictitious individual accountable in that trial. And all of it is essentially a stage, but it does have an effect in reality on real people because of legal chicanery, essentially. And we get a better picture of this when we look at a court case in the United States District Court, Northern District of California. Now, this court case involves the plaintiffs Emil Alperin et al. Versus the Vatican Bank, aka Institute of Religious Works, or Instituto per le Opere de Religione, IOR et al., as the defendants. Now, it's not stated here, but this also does include the Order of Franciscan Friars. And this particular document is a declaration of Professor Settimio Carminani Caridi in support of defendant IOR's, or the Vatican Bank, motion to dismiss Fourth Amended complaint for lack of subject matter jurisdiction. Now, it's important that he does not say that any of the things alleged are false. He simply states that this court does not have the jurisdiction, one way or another, to preside over the separate entity of the Vatican Bank. Now, he's also coming in as a separate entity himself, which is very interesting. Also, it would say that the Institute per le Opere de Religione, Instituto, would be translated as the Institute of Religious Works. That is actually incorrect, because if you were to directly translate that, it would say the Institute for the Operation of Religion, which has a much more sinister ring to it. So that's why they don't translate it correctly. And he is a professor and a lawyer from Rome. On page 7, he defines a juridic person. He says under section 25, quote, "A general analogy between juridic persons in the civil law tradition and corporations in the common law legal tradition may be useful." Of course, notice the way that he is using these words there as a civil law tradition, meaning a form of practice, and corporations in the common law legal tradition. Now, a common law legal tradition is putting law and legal together, and it is changing the definition of law. Law should be a lawful practice in a republic. But in this sense, law becomes a fictional legal term, which applies here, but would not apply in a republic to a common law practice or tradition of the republic. Now, a juridic person, according to him, is a fictitious rather than a natural person, and is similar to a corporation that is created for some particular purpose as may be defined in the founding documents and further elaborated in its bylaws describing the corporate structure and function. Like the common law corporation, the juridic person is a legal mechanism through which organizations maintain a separate identity, structure, purpose, and legal independence. Juridic persons are also classified as either public or private. And then he goes into canon law. However, canon law and much of the information contained in this document is irrelevant because he's coming from the standpoint that the court has no jurisdiction to preside over autonomous and separate entities, where he says in 28, the separate status of juridic persons is maintained through the creation of autonomous governing boards and regulations. And then he also goes on to describe more canon law. And here under 29, he says the sovereign's power, now he's talking about the Pope there, which is a title or position like a king, are divided into pastoral, spiritual, and temporal spheres. Temporal authority concerns the acquisition, retention, administration, and alienation of temporal goods. These powers are exercised by the various juridic persons within the church, independently of the competent authority that created them, within the limits set by their founding statutes. Such canon law juridic persons are also typified by separate legal representation and the power to represent and vindicate the rights of the juridic entity. And here it goes on to state that the IOR, or Vatican Bank, is a public juridic person constituted by the authority of the sovereign in conformity with the canon law, the law of the Holy See, and the law of the State of Vatican City. The legal status of the IOR is described in both sovereign law and legal commentary. And under 35, we get an idea of why this idea of a legal person is important when it states, while juridically separate from the sovereign, the IOR is a creature of the sovereign. It is neither a citizen of the United States, nor is it, that's a grammatical typo there, created under the laws of any third country. Now what this tells us here is that a corporation can be considered a citizen. So, what exactly is a U.S. citizen? Interesting, food for thought there. And then under number 37, it states that the IOR's public purpose is to provide custody and administration of movables and immovables transferred or entrusted to the same institute for the purpose of works of religion and charity. In conformity with its purpose, the institute therefore accepts assets whose destination is, at least in part or in the future, that of the previous section. The institute can accept deposits of assets from entities or individuals of the Holy See or of the State of Vatican City. Now basically what all of this means is that the Vatican Bank, or this institute for the work of religion, formulates the idea of the money changers or the bankers that Jesus had an issue with in the Bible. And of course, this specific institution is relative to the acquisition of items that were robbed by Nazis and other fascists and other mechanisms or entities that were sent out or instigated by the Vatican